Good afternoon. Welcome to the next in our series of webinars presented by the Aoki Center, the UC Davis Law School. And UC Davis would like us to know that they acknowledge that they are on the territorial lands of the Wintun Nation and will conduct themselves appropriately. Welcome to you all. This has been an exciting series so far, and I think today will be equally exciting for you. Our speaker today will be talking about what it's like to practice in tribal courts, both as a practitioner and as a judge. But before we get to that, I know you're all waiting with bated breath to hear who won last week's Pendleton Throw. And that was Ryan Garcia, who is a law student at UCLA. So congratulations. Hopefully that will keep you warm through the bar exam. The purpose of this series of webinars is to try and create a practice community, lawyers, judges, workers, users, staff. And to that end, we ask you to turn on your cameras if you're able. We're not going to be able to sit in the same room with each other. But if you would type into the chat box who you are, who you work for, and how people can get a hold of you, we'll begin to start to create that community virtually. We can't do it in person yet, but if we can get you to turn your cameras on so we can see who each other are, and how to reach out to each other. I know a number of people have connected already to try and help each other. And that, after all, is our goal, to help each other. So today we have a very special presenter. We have Kyle Haskins, who has experience as both a state and a tribal court judge. He has worked for a number of tribal Supreme Courts in Oklahoma, and he'll be talking with us about actual practice. So Kyle, I didn't have a chance to ask you earlier. Would you rather take questions during the presentation or at the conclusion?
Maybe at the conclusion. Let's do it that way.
Okay, then go for it.
Thank you all for letting me be here. It is my honor. I would say, I hope all of you have had the opportunity to learn something about your ancestry. In doing my Cherokee ancestry, my family members came to Oklahoma or Indian country on the Trail of Tears. My ancestors are of the Binge family. I became very interested in where that name came from and how that was adopted. And as you know, my Cherokee ancestors were required to take Anglo names. I was fascinated by what those names were. Some of them were Israel's, which just simply came directly out of the Bible. Some of those names were doubleheads. Don't know where that came from, but I thought it was fascinating. Big half-breeds became last names, and I'm not sure where that came from because they were full-blooded Cherokees. I have always been very proud of my ancestry. It kind of drew me to the law because I always felt like individuals that had law degrees had somewhat of an advantage in the world and dealing with others, whether it was in business and most certainly with regard to any kind of legal matters that arose. And those things seem to affect us all. I'm going to talk about Murphy Mcgirt in a little bit because I've been involved in that for some time. But I will tell you, this is a good time to become a lawyer. So for those of you that are in law school, if you're ever considering practicing Indian law, it's simply exploded as of late. I was a state court judge for 19 years, retired in January of 2016. I spent the better part of a year going to church, a little Indian United Methodist Church in North Tulsa, trying to figure out what the rest of my life was going to look like. I was going through a booklet called One Direction to try to help me find what my purpose was. And as I filled out this book, and there was another gentleman there that was also filling out this book, but he just got out of prison. So we were both sitting there going through these workbooks for having come from different paths, but both looking for our future. My answer kept coming back to serving tribes. I had been on the Supreme Court of the Cherokee Nation for, I think, 8 years. I'm currently sitting on the Supreme Courts of the Pawnees, the Seminoles, the Kickapoos. I had been on the Wyandotte Supreme Court. I'm a federal magistrate for the Court of Indian Offenses at the Miami agency. You know, my mother taught me to give back. We were very poor growing up. I didn't realize it. Ate a lot of commodity cheese and several day-old bread, but it never felt that way. It never felt poor, but my mother always maintained that we had an obligation to understand our ancestry and give back. My grandmother would not teach us Cherokee, even though she was fluent in Cherokee. Her father had made her promise not to teach her family members, her kids and grandkids Cherokee, because he wanted his family to assimilate into a white culture and not be different. So my mother was very interesting in the context that early in her life, she tried not to identify as Native American, but about the time I became a junior high student, and I have an older brother and sister, she began to realize that our culture is incredibly important. You know, my grandmother let Cherokee language slip through occasionally. She always called me Yona, and I never associated that with anything other than being grumpy, because as I was a young kid, getting out of bed, evidently I was a kind of a particularly grumpy young man. So Yona is grizzly bear, and so I always thought that was funny, and I never realized what she was saying to me till later in my life. You know, service is big. I found my way to the Muskogee Creek Nation. They had an opening. I started out really not knowing much about the Creek Nation. Once I got here, I started doing a lot of legal work for the tribe with regard to its Department of Health. It has 3 hospitals and 7 clinics. A lot of historically the tribe was never really involved much in civil litigation, and had some criminal cases, but not a lot. One of the responsibilities that I was given as I got moved away from dealing with the health department was this general civil litigation. And at present, I am the only attorney in the firm that does any kind of civil litigation. And when Chief Lloyd was here, he had directed me to start negotiating with the state of Oklahoma, dealing with Murphy Mcgirt. So I'm going to give you a little bit of behind the doors discussion about that. But I want you to understand, tribal courts are different. And historically, they've been like practicing in front of a small town. Even the decisions that you get, they're based upon traditional law as well as current tribal law. Tribes are obligated to abide by federal law, and they rely upon that very heavily. A lot of tribes do not have heavily established tribal laws as far as case laws, because their tribal courts are just too new. There's Supreme Court justices that sit on those courts often are not lawyers. They're simply traditionalist elders. So it's interesting when you get decisions. And the first thing with the Muskogee Creek Nation, it starts off saying in the Creek language that it is a decision of both traditional and modern law. Historically, tribes are not that litigious. Of the different tribal Supreme Courts that I've sat on, it's pretty rare if I get more than one decision a year. And in fact, I have kind of laughed serving on the Seminole Nation Supreme Court. At their national holiday, it comes up once a year. They spend more time getting me in and out of the pickup to ride the 1 block for the parade, and then get on and get off again. And but it's an honor to serve. And for those of you that have an interest, this is a good time, because tribal courts have exploded, at least here in Oklahoma. So I negotiated a possible resolution to Murphy Mcgirt for the better part of 2 years before Murphy came out. I don't know if all of you are fully aware of those cases. Factually, they're pretty horrific. Mr. Murphy caught a adversary on a dirt road that he did not particularly care for, and it is a case of overkill. Not only did he kill his victim, he emasculated this individual. So as this gentleman was being prosecuted, he was a member of the Muskogee Creek Nation. It happened upon what I'll describe as the historical reservation lands of the nation. And the state of Oklahoma, you had even though it was raised that jurisdiction was a question, you either had a state court judge who either did not understand tribal law or did not care. You had a prosecutor who did not understand nor care about tribal law. He was prosecuted in the state court systems. And, unfortunately, the tribes had sat back for a long time and kind of watched these things happen with regard to tribal members. Same thing, though, with regard to federal courts. U.S. attorneys' offices had kind of sat back and let those things happen. Back when I was in law school in the 80s, I remember a conversation with a group of us that were Native students discussing this jurisdictional issues that have been going on for a long time in the state of Oklahoma, and that the Muskogee Creek Nation probably had the best argument with regard to that those cases should not be tried in state court, that they should be tried in the federal court or in the tribal courts. So Mr. Murphy was convicted. It went up on appeal, went to a federal court. After appeal at the state court level, went to the 10th Circuit Court of Appeals, went to the United States Supreme Court. Justice Gorsuch, who was new to the U.S. Supreme Court, had come out of the 10th Circuit. He did what I'll call a soft recusal, but he decided not to participate in the Murphy decision. They never formally announced that it was 4-4, although I'm quite certain that that was the outcome. And then they did something that was very unusual. They passed that case from that docket to another docket, in essence, to be re-argued. And then comes the Mcgirt case. Mr. Mcgirt is not Muskogee Creek Nation. He's actually a member of the Seminole Nation, but it had factually some of the same circumstances with regard to jurisdiction, except for Mr. Mcgirt is a pedophile. So neither one of those cases factually are those that any tribe would ever want to see receive, national attention, but that's what got there. So Mr. Mcgirt's case gets argued. The tribe paid a very, very good law firm who does a lot of United States Supreme Court work to argue the case for us. They did an excellent job. And of course, it came back 5-4. The state's argument was, Supreme Court, you just can't do this to us because it will create immense amounts of uncertainty. We don't know what will happen. You're going to have people in prison that we put there long ago that are going to suddenly be getting out of prison. We're going to have these massive jail dumps with tribal members. It's going to become the defense du jour that, hey, I'm an Indian, you can't touch me. There'll be questions about which jurisdictions, which law enforcement agencies even have the ability to deal with Indian defendants. And there was going to be civil overlay issues. And also, it would not apply just only to the Muskogee Creek Nation, based upon the Treaty of 1866, but the other of the 5 tribes whose ancestors, like mine, came to the state of Oklahoma on the Trail of Tears. They also had treaties of 1866. So you had this potential explosion that was being argued, this parade of horribles that was being argued by the state of Oklahoma, which, interesting, is not really much of a legal argument. It simply was a plea of impassion. And my belief is, the law was on the side of Mr. Mcgirt. Now, please realize the Muskogee Creek Nation, we fully analyzed whether to get involved and to what extent. We realized, and when I say that, Kevin Dellinger was our Attorney General, we realized what was potentially at stake, but do you stay silent when the sovereignty of your tribe is at issue, or do you step in and protect your tribe's sovereignty and deal with the possible consequences? Most certainly, I don't think anyone really anticipated the full extent of what might come out of the Supreme Court's decision. We simply didn't know. We didn't know which direction they would come. They didn't know if they would create an exception to the Montana test and to Solemn. We're going to have to wait and see. When the decision came out, about 10 minutes after the decision was released, the district attorney in Tulsa County called me. And I know most of those folks from having practiced on the state court bench for so long. They called me and told me to get in my pickup and come to Tulsa County because they had self-identified 58 Indians, and he wanted me to pick them up in my pickup and for us to exercise jurisdiction over those individuals. So suddenly this jail dump started to occur. And while tribes were trying to figure out, the Muskogee Creek Nation was trying to figure out how to deal with this, how to respond, we were also having then to deal with a state who was very hostile. Most of our district attorneys were very angry for a loss of control. Most municipalities were confused. Even the Oklahoma Highway Patrol was uncertain how to respond. Both of our federal courts that were affected weren't even consistent with what they believed to be how to address this. The Northern District believed we're going to wait for the final decision, the mandate from the court to come out, so we have some time to figure it out. And at the same time, the Eastern District said no, they're recognizing what the law has always been, that Congress had never disestablished the historic reservation lands of the nation, and therefore we had to act immediately. So even our federal courts, and by the way, they're wonderful folks, did not agree on how to proceed. We had some cross deputization agreements with some law enforcement agencies, so it did not bring into issue, jurisdictional matters there. We had to, as a tribe, discuss, well, what are we going to do if suddenly, we have jurisdiction over this huge area? How do we respond? The tribe stepped up, appropriated a lot of money for additional light horse officers. Historically, our light horse guys, in all fairness, only dealt with, drunks at the casinos. They were not equipped to deal with white collar crime, crimes of violence. Justice Gorsuch, when he wrote the Mcgirt opinion, really tried very hard to limit that opinion only to the Major Crimes Act and only being a Muskogee Creek problem. But, again, I had been meeting with the state, and Kevin and I, at least 2 days a week for the better part of 2 years. We had what I call an agreement with the state of Oklahoma. Mike Hunter was in agreement, Mithan Mansangani, who was the Solicitor General. We had come to somewhat of a settlement that would have provided for concurrent jurisdiction between the tribes and the state of Oklahoma, and we'd resolved a number of civil issues. That, again, was ordered by the prior chief of the Muskogee Creek Nation, Chief Floyd. We had a change of leadership. With a late change of leadership at the tribe, our new chief did not believe that that agreement was a good agreement that the different tribes had participated in helping arrive at. The tribes then kind of fractured with regard to their response. The big tribes felt like exercising criminal jurisdiction is just too much. It's too costly to build up your law enforcement agencies. You suddenly need a lot of full-time judges. You need big courthouses. You need a lot of prosecutors. You need a lot of public defenders. And oh, by the way, we now need to hire additional Indian Child Welfare Act individuals to deal with all the deprived cases, because under ICWA, in these historic jurisdiction reservation boundaries, we have jurisdiction over all Indian kids. So going from a worker having maybe 2 or 3 cases to, at a state level, having between 30 and 50 cases. So there's this massive obligation to build an infrastructure that suddenly arose. And a lot of the bigger tribes simply felt like if we can just give that back to the state somehow, that may well be a better idea than simply exercising that sovereignty. I have always said that, defending your sovereignty against attack is very expensive and it's very complicated, but actually exercising your sovereignty is incredibly expensive, incredibly expensive. And for those of you that have ever been involved in criminal law, it's just not a money-making proposition. People don't pay their fines and costs. Surprisingly, we do not have debtors' prisons. And for tribes who do not have their own jails or prisons, for every day that we incarcerate someone, we have to pay for it. So even at the federal rate now, we're at $62 a day. So it is a large financial responsibility. It is a responsibility that some of the tribes do not welcome. The Muskogee Creek Nation, we're doing our best. We've hired a lot of prosecutors. We're trying to keep up with the caseload. We're also trying to deal with a somewhat hostile environment from the state of Oklahoma. Most of the jails will not identify tribal members that are incarcerated. So if someone's arrested by a different law enforcement agency, they don't tell us. And we are very slow in getting any kind of reports. So individuals that are put in jail on state holds, they're either simply released, or if we do ultimately get that information, it's typically after they have been released on any kind of state hold. And we're doing out of custody affidavits trying to find these folks who do not want to be found. So it is an enormous responsibility. I always believed that Congress probably would step in. And as things become more and more complex, I think the likelihood of Congress stepping in and disestablishing the historic reservation lands of the Muskogee Creek Nation, and therefore of all 5 tribes, I think increases. There is a case that is before the state Supreme Court. A group of attorneys in Oklahoma City asked me if I would join in a case that challenged the jurisdiction of any municipal court, any district court, state court over any of the lands within the historic reservation boundaries of the 5 tribes. They maintain that no one but the tribes has jurisdiction over any of those areas, including over non-Indians. They asked me if I'd be interested in signing off on that brief, and I said, no, I do not. They wanted to know why, and I gave them my reasons for that. Interestingly enough, they were seeking the court to exercise original jurisdiction. It went to a referee and was argued. The referee evidently has given those attorneys somewhat of a favorable determination. It is going to be heard by the state Supreme Court. If they make that decision that only the tribes have jurisdiction over all the communities, the effects upon small towns could be devastating. They would no longer have the ability to write traffic tickets over anybody. It would fall exclusively to the tribes, and the tribes that simply do not at this time have sufficient law enforcement to provide public protection. If they can't write tickets, those tribal entities would pretty much just fail. The tribes certainly cannot pick up the cost of maintaining those tribal entities. A lot of individuals, tribal members, kind of like myself, Cherokees who live now on tribal lands, and I live on the tribal lands of the Muskogee Creek Nation, started making application to the Oklahoma Tax Commission saying, hey, I don't have to pay state tax anymore. Never have, and I'm going to go back 3 years, and here's my applications for refunds. I've been paying taxes, shouldn't have, you owe it back. Interestingly enough, the Oklahoma Tax Commission started paying those refunds. Somewhere along the line, I think our governor got involved and said, you need to stop that because you're going to bankrupt our treasury. And then the tax commission sent letters to those individuals saying, hey, we mistakenly gave you refunds. You owe that money back, plus penalties, plus interest. So now there's going to be litigation over whether tribal members within most of all of eastern Oklahoma even have to pay tribal tax or state income tax. Issues are now arising with regard to whose tax rate applies and whether it's trust property, restricted property, fee property. Murphy Mcgirt has thrown open a large door, if you will. It's complex. During the time that I was negotiating with the state attorney general's office, the governor of the state of Oklahoma decided that he did not like the gaming compacts with the tribes in Oklahoma. It felt like that they've been overly successful, far beyond the dream of the individuals who entered in those compacts. And he commented they were coming to an end and all gaming was going to be illegal come January 1, unless the tribes renegotiated with him. However, the gaming compacts had automatic renewal provisions. He ignored those under the advice, as he said, of his counsel. So we ended up dropping our continued negotiations with the state, ended up in litigation with the governor's office in the Eastern District, Federal Eastern District, and we prevailed on summary judgment there. That governor obviously is not happy with the tribes in Oklahoma, nor are they happy with him. He has openly announced he will not enter into any kind of compacts with the state of with any of the tribes in the state of Oklahoma, because he believes that they unduly favor the tribes. So we're in an awkward place. Tribes are hiring. You know, for those of you who are going to be looking for jobs, if you're looking for any kind of tribal work, and you know, it's not, as with me being involved in different tribes, it's not that unusual. You know, folks, once you get start working for one tribe, the other tribes believe that you know, if one tribe thinks they have some trust in you, then we are too. So it's not unusual to see these journeymen between the tribes. It certainly helps if you're a member of that respective tribe. If you apply there, it helps. Then secondarily, if you're not a member of that tribe, if you're a member of any other federally recognized Indian tribe, but tribes are starting to come around and realize, hey, we just need to hire the best people, even if they're a non-tribal member. So for those of you who might have an interest someday, certainly look into that. I would be pleased to ever answer any questions you may have, or if you're looking for work in this direction, I will help you to the very best of my ability. I'd be glad to talk to you more about Murphy Mcgirt issues. But as we stand right now, there's a lot of confusion. A lot of the questions that come to me are with regard to, well, what does your tribe do? You know, where do we find your laws? Well, you know, tribes in the past never had to be that sophisticated. A lot of our laws ultimately make it into digests. Ultimately, they become available. You know, there's big stacks of papers over with our legislative bodies with regard to new laws that have been passed that nobody really even knows about unless you were there. So the people that work in the Attorney General's offices frequently are wealths of information themselves. You know, I have attorneys that call me and say, well, where's this particular provision? And unfortunately, when laws are codified, they end up in places they don't belong. So, you know, if you get involved in a lawsuit, there is nothing wrong with contacting the attorney on the other side if they work for the tribe and talking to them about applicable laws. Certainly, I would encourage you to never rely upon state law. Tribes are very jealous of their own laws. And if their own laws don't apply, then going to federal law. It is okay to cite state law if you have nothing else, but tribes are not subject to state law. So while it may be informative, while it be saying something for the tribe to consider, state laws are certainly not binding. You know, there's not a lot of litigation historically with regard to the tribes, but suddenly that has exploded. There's a lot of it. I anticipate a lot more coming our way unless Congress does disestablish. I am worried that if this case that goes to the state Supreme Court, if they determine that no other tribe has jurisdiction over any issue, whether you're a tribal member or non-tribal member in eastern Oklahoma, I think that that's probably an invitation for the federal government to get involved. If that happens, I think Murphy Mcgirt came out on a Thursday. If that happens, it would be my hope that any intrusion by Congress would be to put us back to where we were on Wednesday, you know, the day before the decision came out. My concern would be also if they decided to fix the problems they perceive with tribes. My concern is the second sentence and the third sentence and the fourth sentence, meaning to say, I think they may go further and address other issues that they perceive to be out there with Oklahoma's tribes. So there's a lot going on. It's very complex. I truly am blessed to have been involved in what I consider to be some of the most significant, you know, tribal issues that have ever arisen in the state of Oklahoma. Again, when I took this job, I thought it was going to be kind of a cushy thing to do in my retirement. I was only going to be dealing with interdepartmental disputes here with the Muskogee Creek Nation, but that's just not the case. So if you all have any questions, I would certainly welcome those. I could go on and talk about this for a long, long time, but I would just want to point out that there's a lot happening, and it will be fun to watch and see what happens in the future. And so with that, I'll turn it over to any questions that you may have.